Thank you. We would acknowledge receipt of the information, waive any further reading, and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
27th at 1:30 before Judge Slate Thursday.
June 27, 2024, 1:30, Slate Thursday.
All right, pause right here. What you're about to watch may look routine, but this is actually one of the most critical moments in any criminal case. A defendant is about to waive a preliminary examination, and that single decision can quietly change the entire legal strategy. The question is, smart move or risky gamble? Let's watch closely.
Good morning, Silvana Reed, Assistant Public Defender with and on behalf of Mr. Ruggs.
All right. This is going to be a waiver.
That is correct.
Mr. Ruggs, you signed this examination waiver?
Here's the legal translation. A preliminary exam is basically the prosecution's first test drive of their evidence. By waiving it, the defense skips the chance to challenge witnesses early. Sometimes attorneys do this to avoid revealing strategy, but it also means the case moves faster toward trial pressure. High risk, high strategy.
Yes, I did, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
And you understand that you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit.
Notice the phrase, stand mute. That doesn't mean silence out of confusion. It's actually a legal tactic. When a defendant stands mute, the judge automatically enters a not guilty plea. It protects the defendant while buying the defense time. Ever wondered how many courtroom moments sound dramatic, but are actually procedural chess moves? This is one of them.
Court on count 1 with 2 following. Street.
Thank you. We would acknowledge receipt of the information, waive any further reading, and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
27th at 1:30 before Judge Slate Thursday.
June 27, 2024, 1:30, Slate Thursday. Bond with its conditions will continue. Thank you. Yes.
Report the note in my file from the other APA group that you saw in violation.
And now the tone shifts completely. We move from paperwork to personal accountability. Bond violations are serious because they signal whether a judge can trust a defendant outside custody. Judges aren't just listening to excuses. They're evaluating credibility in real time.
That's today.
Yeah.
The May 17th, 2024 bond violation report.
I do. Is there a reason why you were missing? You were testing elsewhere, weren't you?
No, sir. I was told I needed a court order, and I was on video Zoom with you on my last court order, and nobody contacted me and told me where to go.
Why didn't they?
I do have information about a facility that he would like to test at. He lived in Macomb County. We
Yeah, I'm on GPS. Oh, I'm sorry.
called them and they indicated as long as the order indicates what sort of panel needs testing and the frequency.
Well, that was supposed to be done before. If I give you a test today, are you going to test?
Yeah, the only thing I'm going to fail for would be marijuana. Yeah.
Why are you using that?
This is one of those rare courtroom moments where strategy pauses and humanity steps in. Admissions about addiction can help explain behavior, but legally, explanations don't erase violations. Judges must balance empathy with public safety, and that balance often decides whether someone walks out or leaves in custody.
Speak freely.
Yes.
Your Honor, I'm going to be up and honest with you. I used to have a crack cocaine addiction, and I've come a long way. I've been through a lot, this past few months. I lost my father, my grandmother. There's no excuses. It's just the only thing that I've helped to.
Give me an order. Okay, he's going to go over to community corrections test today. I'll get the results and then I'll determine what his bond will be as he proceeds up, because he's told me what's going to happen, and then we'll figure out. In the meantime, counsel can prepare an order so that he can test in Macomb. Okay.
And then just to be clear for the record, the waiver is complete and we're only coming back on whether or not they'll be remanded.
Pardon?
The waiver's all set now?
Well, technically, no.
Got it.
Because, technically to retain jurisdiction, but I still have jurisdiction anyway. So he needs to go over and test, and then we'll figure out what we're going to do.
Okay. Thank you.
Thank you.
Thank you, Your Honor. Nicole, please on behalf of the people.
Sylvana Reed, Assistant Public Defender with and on behalf of Mr. Ruggs.
As we were walking out of the courtroom, I went to release the deputy who is present. I did not believe that the victim of the domestic violence was present today because she didn't check in with us. As we were leaving, the deputy let me know that the victim.
And this is the moment everything changes. In domestic violence cases, no contact orders are absolute. Even casual conversation can count as a violation. What looked like a routine hearing suddenly becomes a custody decision. And judges take these violations extremely seriously because they relate directly to victim safety.
The victim was actually present today with the defendant sitting beside him. As we exited into the hallway so that I could see who the deputy was referring to, the defendant was speaking to Ms. Perkins out in the hallway, and the deputy confirmed that that is the victim. There, as I understand it, based on everything that's filed, there's a no contact order. That, in addition to the corrections violation, I'm requesting that he be remanded and that its bond be revoked.
That's not my problem. She was in court.
Mr. Allen, thank you, sir.
Your Honor, I have no further information at this time.
Does he admit to the violation?
You're on. Not straight.
If you wish.
She wasn't here with me today, Your Honor.
Were you talking to her in the hallway?
She made a comment to her in the hallway. We were talking to her about testing, and I said something that I didn't.
Were you sitting next to each other in the courtroom? You know I can get video from the courtroom.
Oh, yeah, I
So-
understand that. Yeah, she was sitting next to me.
You're not to have contact with her. You know that. Forget the testing. Defendant's bond at this time is revoked. Defendant's remanded. It'd just go up before Judge Slay. I'll just leave it there.
Thank you.
Your Honor.
And just like that, bond revoked. What began as a procedural hearing ended with immediate custody, proving how fast courtroom dynamics can shift. One waived hearing, one admitted violation, and one prohibited interaction changed the outcome entirely. The real lesson? In court, every action, even outside the courtroom doors, still counts.